Bill Groh, and welcome to 90-Second Legal. The Colorado Non Compete Statute has an interesting provision governing when you can enforce a non-compete intended to protect trade secrets. The employee has to be a highly compensated employee at two different times. One, when it is entered into, which is simple enough, and two, when the non-compete is actually enforced. But what does enforced mean? The statute doesn't really tell us. The answer to this question matters because if the former employee is not highly compensated at the time of the enforcement, you can't enforce the non-compete. So when does enforcement occur? Is it the date of a cease and desist? How about when a suit is filed, or when a judge enters an order enforcing the non-compete? What if that order is a preliminary injunction? Does that count? Maybe the day a permanent injunction is entered. We don't know exactly. There was a recent holding where the District of Colorado looked at this issue briefly and issued an injunction to enforce a non-compete. In that case, the court determined the employee was highly compensated when the non-compete was entered into, as well as on the last day of the employee's employment with the plaintiff. Now, the parties didn't dispute this issue, so the court didn't specifically analyze it. So the case doesn't tell us a whole lot, but it does at least suggest that the last day matters. Notifying an employee that you will enforce their non-compete on their last day could end up making that last day the date the court uses to determine if the employee is highly compensated. If you wait until after that, the court could maybe use a different date. Perhaps the employee would no longer be highly compensated at whatever future date the court ends up using. For more information, check out the links below and click that subscribe button to get more 90-second legal content.